Beginning. Okay, let's start over if I can. Okay. Yeah, we're live. This is happening. All right. Check screen. Starting slideshow. Okay. Good afternoon, ladies and gentlemen. Let's kill that tab so we don't have an inception kind of thing going on. Permanent feedback loop. All right, so welcome to Nevada Legal Services YouTube Live. This is our habitability presentation. We are going to talk a bit about what to do when things are wrong in your apartment, what you can do about it, how to deal with your landlord, and what your rights are. So, what to do when your home's unacceptable, freezing, and or vermin infested. All right. So there are three main types of ways of addressing a habitability problem. There are habitability under NRS 118A, essential services under NRS 118A, and lease violations. And any one of those things could be a means of addressing the issue that you're having in your house. Habitability seems like a term with a common sense definition, but of course, this is the law, so everything is defined in the statute. So the first thing to do is determine if your problem is a habitability problem, an essential services problem, or a lease violation problem. And we're going to start with a habitability problem here. So what is the definition of a habitability? Nevada law does require landlords to maintain habitable dwelling units. So if your apartment, the house you rent, if you rent a mobile home and also the land it sits on, you are in the land of NRS 118A, which means there are requirements for the landlord to maintain it in a habitable condition. And habitable has been defined in NRS 118A 290 as capable of allowing an average person to use and enjoy the dwelling and live free of defects affecting health or safety, meaning you must have hot and cold running water, the roof, floors, and walls can't leak, there has to be working toilets, doors and windows have to open, close, and fit properly, electrical outlets and wiring have to operate safely, and it has to be free of garbage, rodents, insects, and vermin, and they have to have adequate heat. Other services like air conditioning, ventilation, elevators, appliances, things in common areas and not in your dwelling units are much more arguable. They can be habitability problems, though, if they were supplied by the landlord when you moved in or if they're required in your lease, which does mean, as awkward as it is, if your lease doesn't mention it, you should, when you move in February, check the air conditioning and make sure it works, and so forth. Because if it's not working when you move in, then it becomes much more of an issue to show whether or not you're entitled to it under the law. So, all of these problems essentially begin the same way. The tenant must provide a written notice to the landlord describing the problem. Habitability problems under 118A 290, so, you know.
But Daniel, what if I just tell the landlord that there's a problem? Isn't that enough?
No, Stephanie, that is not good enough. It's never been good enough.
But it's good enough in California.
Well, this is not California.
So Nevada actually requires it to be in writing?
Yes, very much so. Life is harder in Nevada than it is in California, Stephanie. Um, despite popular despite popular rumors.
But what if the
have you.
landlord knows it's a problem?
Well, technically, if the landlord knows it's a problem to the point where he or she admits that they knew about the problem in court, you can get around written notice, but it is extremely unwise to rely on that.
Do I have to put a date on it?
Yes.
Well, what if the landlord says they lost the notice? How will anyone ever know that I gave the landlord that letter?
Well, you would have a copy that you kept showing when you mailed it to the landlord.
Is it okay if I just take a copy with my phone, like a picture?
I mean, it could be okay as long as you can get to a printer from your phone.
What
Yeah.
if I send the landlord an email? Is that okay?
An email is written notice, yes. So yes, the tenant must provide written notice to the landlord describing the problem. And that's going to be true for habitability problems, essential services, and lease violation problems. If you've got a problem with your landlord, it has to go in writing. If it didn't go in writing, it didn't happen. If the landlord for habitability problems doesn't take their best efforts to fix the problem within 14 days of receipt of the notice, then you as the tenant can terminate your lease, seek to recover actual damages, seek other relief in court, and or withhold your rent. However, if the landlord does try in good faith to fix the habitability problem, you can't pursue those remedies, which means if your toilet breaks and you call your landlord and the landlord calls the plumber, then that's sort of the end of the issue. You can't then withhold your rent. You would have to give another written notice and start again. Withholding rent is always a dicey proposition. The tenant cannot withhold rent if the tenant already owes the rent to the landlord when the notice is sent. So if you're behind on rent, as a lot of people are right now, you can't withhold rent if you start out while you're behind. Technically, according to the law, if you are withholding rent, you must deposit the withheld rent in an escrow account with the justice court. The justice court would be the justice court for your jurisdiction. Reno has a justice court. Sparks has a justice court. And the law does require that they have some mechanism to hold rent in escrow. So if you are withholding rent, that doesn't mean that you can just take it down to the store and spend it on groceries or spend it on other things. That rent has to go into an escrow account because when the landlord tries to evict you for not paying your rent, the court has to be able to go, oh, look over here, there's the rent, they're lawfully withholding it. And if the court decides against you, then the landlord just gets the rent. If the court decides in your favor, then the court will give you your rent and you can spend it as you see fit. All right. So, tenant does not have a defense to an eviction unless the tenant's deposited the withheld rent in an escrow account. In most cases, as a practical matter, the justice courts don't absolutely expect you to know that it's the law to put the rent into an escrow account. So as long as you have the rent available and ready to go when you get to your hearing, it's usually fine. But the proper way to do it is to put the rent in the escrow account with the justice court. So if the cost of a repair for a habitability issue is equal or less than 1 month's rent, you have the option of repairing and deducting. So if the landlord fails to fix or make any effort to fix the problem within your 14 days of the written notice, and if the cost of the repairs is less than $100 or equal to 1 month's rent, whichever is greater, the tenant can repair the problem at the landlord's expense, meaning you can just sort of call your own plumber and then withhold just that amount. However, again, you can't use this remedy if you started out behind on rent. You can't use this remedy if the problem was caused by deliberate or a negligent act of the tenant or a member of the tenant's household. So if your kid flushed a toy down the toilets, your landlord is probably not going to be on the hook for your children breaking things in the household. And the tenant can only use this remedy once during any 12-month period. I don't think I've ever come across a situation where people were having to use this remedy more than once in a 12-month period, but it pays to be aware that that's out there.
What if my rent is $1,000 and it's only going to cost $1,015 to fix this issue?
Then you can't repair and deduct.
Okay.
You would have to withhold your rent, or, as unfortunately Nevada laws, or revert to what seems to be Nevada law's main idea as a tenant, is you can move out if you have a habitability problem.
Does the landlord have to pay for my moving expenses?
No, generally. No, he does not.
Hey, would you like to learn about some essential services?
I would love to learn about some
Okay,
essential
let me
services.
tell you about essential services. So essential services are a bit more than habitability. These are the super important parts of your housing. So heat, hot and cold running water, electricity, a working door lock. Those types of things are essential items or essential services. So, hey, we live in Nevada. What about air conditioning? Is that important?
Yeah, it's really important. People die without air conditioning in Vegas.
In Vegas, right?
Yeah.
So in Southern Nevada, like Vegas, judges have recognized air conditioning as an essential service. But up here in Reno, you're going to need to check your lease to determine whether that's an essential service. And also, as Daniel said in the last one, make sure it works upon move-in. So also for essential services, if you want to use this remedy, which is a little bit different than the habitability remedy, it can't just be broken or missing. It has to be a result of the landlord's willful or negligent action or inaction. So if the essential service is not the result of the landlord's willful or negligent actions or inactions, then you can still use the procedure of habitability violations or lease violations, but you can't use the essential service procedure.
So if my friend comes over and kicks my door in, the landlord doesn't have to do anything about that?
Well, it's not going to be an essential service. You can't use this procedure right here, but you can request the repair. You might actually, if your friend comes over and kicks your door in, you might actually end up being responsible for those charges. But if a third party, like a robber, comes in and kicks your door in, you wouldn't be responsible for those charges. It's going to depend on if it's your guest, someone you have control over.
I see.
Good question. So what is the procedure for essential services? Once again, tenant must provide written notice to the landlord describing the problem. And if the landlord fails to fix the problem or fails to use best efforts to fix the problem within 48 hours of receipt of the notice, then the tenant can use these remedies. And that 48 hours does not include weekends or holidays. So tenant can pay to obtain reasonable amounts of an essential service, and then they deduct the cost of those essential services from the rent. A tenant can sue the landlord for actual damages resulting from the lack of essential services. The tenant can withhold rent. Or if it's a very serious problem where it makes the rental property uninhabitable, then the tenant can obtain comparable suitable housing. While the tenant is in this alternate housing, the tenant doesn't owe landlord rent for the original rental property. Also, if the substitute housing costs more than your original rental property, then you can sue the landlord to pay the difference between your original rental property and the substitute housing. If you'll notice, termination of the lease is not available under the essential service remedies, but there's a lot of overlap between essential services and habitability. So for a lot of these, you could use the habitability procedure, which again requires 14 days, not 48 hours, if you want to use the remedy that allows you to terminate your lease immediately.
So for written notice to my landlord, can I just send him a text?
Well, are you going to be able to use that text to prove in the future that you sent that?
Well, I mean, I have it in my phone.
Are you going to hand your phone to the judge? What if your phone breaks? What if you lose your phone?
Oh, so maybe it's not a great idea to just use a text.
Not the best. Could you send an email instead?
I suppose I could.
Or even better, just write out a letter and hand it to the landlord after making a copy for yourself.
Okay.
Okay. So there is another procedure for essential services that is available in addition to the 48-hour notice. And this is called a verified complaint. And this covers a lot of different things. So it could be an intentional utility shutoff, for example. Sometimes landlords might be angry if you're behind on your rent, and then they just turn off your utilities. Or they might even try to lock you out without going through the proper court procedure. Or what I saw in some neighborhoods back when I practiced in California is that one particularly notorious landlord, when tenants became late on the rent, would take the door off the hinges. So the tenant no longer had a front door. These are all serious problems and considered essential service violations. And in these cases, if the landlord willfully interrupts or causes or permits the interruption of any essential item or service required under the rental agreement or under this law, then the tenant can file a verified complaint, and the court needs to schedule a hearing within 3 days after the complaint is filed. So this verified complaint that we're talking about, this is an expedited relief. It's a lot quicker than other lawsuits. Other lawsuits, once you file your complaint, you'd have to wait a month before the other side even has to respond to your complaint. With this very special expedited procedure, it again, you only have, it's 3 days after you file the complaint that you have to have a hearing. But if you want to use this verified complaint, this expedited procedure, you have to file the complaint within 5 judicial days of the interruption. So 5 judicial days, that means same as business days, no weekends, no holidays. And so if the landlord turns off your utilities, turns off your electricity, shuts off your water, then you have 5 business days from the date of that shut off to file this verified complaint. So this deadline, it applies to the expedited relief only. If you miss the deadline, you're still allowed to sue the landlord in a regular lawsuit for damages that result from the utility shutoff. But you don't get to use this super quick method. You're going to have to go into the long line of cases where you're waiting months and months for your case to even be heard. Also, with these verified complaints, you're not allowed to file a verified complaint if you're already in eviction proceedings. So if your landlord has already given you an eviction notice and you've already filed a tenant's affidavit, so you've already got a hearing coming up for your eviction, then you can't just file a separate verified complaint. Instead, what you need to do is you need to file a motion for expedited relief for the utility shutoff or the illegal lockout. You kind of want to watch out, though, if you are in an eviction hearing, to make sure that the hearing for your verified complaint doesn't somehow become a hearing for your eviction. So make sure that the judge understands what you're there for, whether you're arguing on the motion for the expedited relief or whether you're actually at the hearing for the eviction. Because, judges often have a very heavy docket and they can get a little bit confused if there's 2 separate issues in one single case. So what are the remedies that are available to you with this expedited relief? Well, you can get $2,500 in statutory damages. Now, statutory damages, that means that you don't have to prove that you incurred $2,500 in damages as a result of the lockout. It's just the statutory damages. The judge doesn't have to award all of that to you, but it's available. And it's going to depend on whether the landlord acted in bad faith, how egregious the landlord's behavior was in this particular situation. Then in addition to the $2,500 in statutory damages, you also get your actual damages, which means your out-of-pocket expenses. So let's say that your landlord takes the door off your hinges, and so you no longer have that essential service of a working locking door. Well, you can't stay there if the door's off the hinges, so you're going to have to go find alternate housing. So maybe you have to go and stay in a motel for a couple of days while you're waiting for your hearing. That means that your out-of-pocket expenses would be the cost of the motel. In addition to the statutory and the actual damages, you're also entitled to immediate recovery of the unit. So if it's a lockout, you get back in if you win. Also, you have the option to terminate the rental agreement if that's what you want. You can also get a court order where the judge prohibits the landlord for additional willful interruptions of utilities. And the result of a violation of this order would be that the landlord would be held in contempt of court.
So if my water heater breaks and my landlord willfully refuses to fix it after I tell him it's broken, I can file a verified complaint for utility shut off?
Nope. It has to cause or permit the interruption. So if you tell the landlord that it's broken, you can get that 48-hour notice. You can give them the 48-hour notice saying, and then you have the remedies available from giving the 48-hour notice. But if the heater breaks on its own, and then you inform the landlord of that, you don't just get to go straight to verified complaint. So it depends on whether the actions the landlord has taken.
Okay.
So different remedies for different actions and different levels of culpability on the part of the landlord.
So if my landlord turns off my hot water and then I have to go take showers at my friend's house, how do I show that I've been damaged?
Well, there are a few different ways. How far away is your friend's house? Do you have to drive? Does that take gas money? What about, is your friend a nice friend who lets you do it for free, or are they charging you $10 every time you go in there to use their shower? Does your friend want you to pay back the cost of water? It really depends on the exact circumstances of your individual case, but make sure that you keep receipts. So if you do have to go over to a friend's house, keep track of mileage, keep track of your receipts from every time you have to go get gas. It adds up if you're going through a long period of time without essential services and you have to get them all from other places other than your usual place of residence.
Okay. So do you want to talk about lease violations now?
Sure, let's talk about lease violations.
So lease violations are very similar to habitability problems and essential services problems, but they're also a lot more broad because you can put basically anything that you want into a lease. So while, say, a broken dishwasher would not fall under habitability, there's a real possibility that something in a lease addresses like a broken dishwasher or landscaping or use of common areas, etc. So if the elevator is a little broken at your apartment complex, that may not be a habitability problem, but your lease might address it. And your landlord is obligated to comply with the lease that everybody agreed to when you moved in. So lease violations can be very useful when the issue you're having with your landlord doesn't quite meet habitability or essential services, but it's still bothering you. So always check your lease to see what your landlord's required to do for you, because that's the agreement that you guys came to when you moved in. Lease violations are like habitability problems in that the tenant has to provide the landlord with 14 days of written notice of the problem. They're also a lot like habitability problems, where the remedies are if the landlord doesn't make their best efforts to fix the problem within the 14 days of receipt of the written notice, the tenant can terminate the lease and move out, sue the landlord to recover actual damages, or apply to the court for other relief deemed proper by the court under the circumstances. Generally, you cannot withhold rent for a lease violation, even if you're up to date on your rent. The lease violation rule is also 1 month's rent. If the problem is bigger than 1 month's rent, it may be the best idea for you to just sort of break your lease and move out and find a new place to live. If the landlord fails to fix the breach within 14 days of the tenant's written notice and the cost is less than $100 or equal to 1 month's rent, whichever is greater, then the tenant can remedy the breach at the landlord's expense. and the tenant cannot use this remedy if the problem was caused by deliberate or negligent act of the tenant or member of the tenant's household. And the tenant can only use this remedy once during any 12-month period. Again, I have not seen this come up more than once in a 12-month period, but it helps to know that the rule is there. So yeah, for example, if the elevator is broken, that is very likely to cost much more than 1 month of rent to repair. So trying to repair that on your own is not likely to be an option. But if, say, your dishwasher is broken, you may be able to, if you get a cheap enough dishwasher, you may be able to replace the dishwasher, provided that your lease says, hey, the dishwasher is the landlord's problem. But again, you want to be real sure that your lease says that the dishwasher is the landlord's problem before you do that. Because if you spend the month's rent on that instead of rent, you will be in the same place as withholding rent under habitability, and your landlord will likely try to evict you for non-payment of rent.
So what happens if either you withhold rent or you use the equivalent of 1 month's rent to fix the problem for a habitability violation or a lease violation after having given the landlord all the proper written notice? And then, of course, you have to, so you've withheld rent and the landlord gets angry and they give you a 7-day notice to pay rent or quit.
Right.
What do? Where do you end up?
You end up at an eviction hearing because a 7-day pay rent or quit notice always requires a response to the court. So you would have to file a tenant's affidavit. Otherwise, the landlord would be able to walk into the courthouse and get a lockout order against you, essentially with no questions asked. So you would have to file a tenant's affidavit and attach the written notice that you sent your landlord, because of course you made a letter, you got yourself a copy, you photographed the envelope the day you put it in the mail, what have you. You can show that the landlord had notice and that the 14 days passed and the landlord did nothing about it. So you had no other option but to fix the problem yourself.
So I can use this as a defense to an eviction for non-payment of rent?
Would be a defense to an eviction for non-payment of rent.
And I need to bring proof if I go to court?
Yes. While we're talking about rent evictions, it might be helpful to go over the status of eviction moratoria in the United States of America at this point in time. The Center for Disease Control does have a moratorium on evictions, which does include rent evictions. So there is a CDC declaration.
Well, what about the Nevada moratorium on evictions?
Nevada's moratorium on evictions has come to an end, Stephanie.
When did that end?
It ended on October 14th. So landlords are allowed to, under Nevada law, give rent eviction notices now, and all of the other kinds of eviction notices.
But the CDC said, the Center for Disease Control said that if your state doesn't have an eviction moratorium, then you can use the CDC eviction moratorium.
The CDC has said that, and you can submit a CDC declaration, though the CDC's protections do require you to jump through hoops. For example, you have to show that you were making a good faith effort to make rent payments, and you have to show that you've applied for rental assistance or been making a good faith effort to acquire rental assistance, which can be tricky when you've done something like withheld your rent or spent your rent on something else. So if the landlord decides that the CDC declaration is not up to them or not up to their standards and takes it to court anyway, you will be in a position of showing the court, one, that you gave the landlord a CDC declaration informing them, and also kind of in a sticky position of arguing about how you were supposed to spend your rent money, which may or may not go well depending on where you end up.
But those are two different defenses, right?
Those are two different defenses.
You've got the CDC eviction moratorium. If you fulfill those requirements, can't pay your rent because of COVID-19, have an income under $99,000 a year. Or the other defense if you've given your 14-day notice of lease violation or habitability violation to your landlord and are either doing the repair and deduct or the full withholding of rent, depending on the individual circumstances of your case.
Right. And on the bright side, either of those defenses should be sufficient to get an eviction dismissed. So.
But I still have to go to court. I've done everything right. I've given a letter to my landlord. I've repaired a deduct. I've fixed the problem myself because after 14 days, the landlord didn't do what they were supposed to do.
Right.
And after all that, landlord's still going to give me a 7-day notice of lease violation. And I still have to file a tenant's affidavit.
You do still have to file a tenant's affidavit.
And I still have to go to court.
And you do still have to go to court. Because if you don't do those things, the court will assume that you don't care and will just evict you. And as far as that goes, landlords, remember that if someone does give you a CDC declaration and you opt to ignore it, there are penalties for ignoring the CDC declaration, including some pretty hefty fines and, in the law, threats of jail time. So
violating the CDC eviction moratorium has criminal penalties for landlords.
It can have criminal penalties for landlords. It is a very serious thing. So you may want to consult your legal counsel before you decide to just ignore it. Substitutes for written notice. See, sometimes you don't have to give written notice. You can get your landlord to admit in court that they had knowledge of the lack of essential items or services, or that they received written notice from somebody else.
So Daniel, how often does it happen that a landlord admits in court that they have knowledge of the violation?
I would say not quite never, but it is very unlikely that the landlord will admit in court that they had knowledge of the lack of essential items or services.
But let's say I've told the landlord a million times about this problem. Is there really a chance that they're not going to acknowledge that in court?
Yes, absolutely.
So would the safe thing to do just be to give the landlord the written notice?
That would be the safe thing to do. That would be the right way to do it.
And keep a copy for myself.
And keep a copy for yourself.
Just in case I end up in court.
Just in case you end up in court. Because sometimes even if we do everything right, we end up in court. There is also the possibility that your landlord has received written notice that the apartment or dwelling unit is uninhabitable because a government agency authorized to inspect for violations of building, housing, or health codes has provided the landlord with a written notice that the condition is uninhabitable. So if, for example, code enforcement shows up and tells the landlord that there's a habitability issue there, the landlord does have to address it. And that notice is just as good as if you had given written notice. And in fact, if your landlord is not listening to you, you can always call code enforcement yourself, but there is a major risk to that we will get to on the next slide. So if the tenant chooses to go for monetary damages under NRS 118A 350 or 355, then they don't need to provide the written notice if the landlord has already received notice from code enforcement or another government agency that there is a problem bad enough that the government has had to get involved. So if there's, like a gas leak or the house is caving in, as in this photo, you might be spared having to write the written notice yourself, but also there's no harm in sending your own written notice too. It's just extra notice to the landlord. And the downside of calling code enforcement is that if your apartment is in fact uninhabitable and the problem is very serious, then code enforcement can condemn the rental property, in which case you would have to move out anyway.
Wait, isn't code enforcement the purpose to help me as the tenant?
No, code enforcement exists to ensure that all of the buildings are up to the building code. And unfortunately, the people living in the building can't live there if the building is not up to code. So it's one of those situations where it will hurt your landlord, but also it can hurt you if the problem is bad enough that code enforcement actually condemns the rental property instead of issuing a citation. Often they do just issue a citation, but you always want to be aware of that possibility if you are in a situation where you're desperate enough to call code enforcement. I don't know how we do questions on the Facebook Live format. We'll go right to the thank you for your attention slide. For those of you who are watching this now or in the future, if you have any questions, you can always contact Nevada Legal Services. Our Reno office is located at 204 Marsh Avenue. It's right on the corner of Plumas and Marsh, right next to sort of where Plumas hits California. Reno, Nevada 89509. Our phone number is 775-284-3491. If you are anywhere in the state, you can call our toll-free phone number, 1-800-323-8666. And you can always even send us a fax if if that's something you feel like doing, 775-284-3497. So I'm now, I don't know. Is there a way to even take questions? Participants 1. And I think that'll be all. So I'm gonna put an end to this thing. All right. So stay safe, stay warm, and